Please. Okay. May it please the Honorable Lordship, with the Council of Petitioner who like to propose and state a case under Article 226 and 227 of the Indian Constitution. We stand before you in current situation because of the gross misuse of statutory power under the Article 14 of our Indian Constitution. Also, the illicit laundering and offshore manipulation of public funds and sudden but suspicion death of Mr. Rohan Mehta. May your Lordship permit, may I please put up some important facts which are necessary for my podcast. The Municipal Corporation of Virudhunagar invited developers to propose integrated housing models on government land under the Slum Declare Act, Section 302 of Virudhunagar Slum Development Act 2010. MCDM claimed that these services of slum under police slum were provided under humanitarian conditions. Allegations emerged that Vaidari constructors had influenced MCDM to do so. Further, on March 20, 2023, notification was issued to declare that land as a slum, and nearly 2 months later, a tender was issued and a tender was granted to Vaidari Constructors Private Limited. Owing to this, further there were a series of leaked emails which came online which showed that there was some collision between MCDM officials and Vaidari Constructor Private Limited. Entries showing overseas consultancy was seen for the foreign share entities namely Crystal Global Limited and Onsway Holding Private Limited, registered in Singapore. Then High Court further constituted a special investigation committee, hereby SIC, to look into this matter. Rohan Mehta, a 34-year-old financial consultant who has previously worked with Vaidari Constructors Private Limited, has then given up his resignation. On 12 June 2024, unfortunately, Rohan was found dead in his apartment at Lake Towers. The police cited lack of conclusive evidence and closed the case within 15 days. Further to that, Ms. Ananya, a close friend of Mr. Rohan Mehta, approached the court with the digital evidence in August 2024. Further to this, and the SIC which was formed, it was directed to ED Enforcement Directorate and Serious Drug Investigation Office to continue the further investigation. Rashid, if you are reversed with the facts, may I proceed with the issues for consideration? Much obliged, Rashid, may I have your attention on petitioner's memorial, page number 18. Sorry, what? Please, number 1. Yes, sir. Rashid. Lordship, for the issue number 1, whether a conferment of redevelopment rights under the Vidya Slum Redevelopment Act 2010 in favor of Vaidari constructors violates the constitutional principle of transparency and equality under Article 14, or whether such conferment deteriorates a valid administrative act within the permissible limits of discretion. Your Lordship, I would like to refer to the Article 14 of our Indian Constitution. In the present case, the conferment of redevelopment rights upon the Vaidari constructors reflects a decision-making process that lacks objective. Yes, Lordship.
What is that? What was that?
Lordship, no, I'm following. Lordship, what the trying to say that
the purpose is said equality is a dynamic concept. Is that right?
Yes, sir.
How is it here?
Lordship, what we are trying to say over here, this is that equality is a dynamic concept. However, what has happened over in this case that particular private consultant, there is the private consultant, where they consider private limited, has been given duly advantage over others, bearing the equality clause. Hence, we have stated this clause over here.
How it is there? The varying construction of charge is the varying construction is preference over others. So how? It's whether there was some option for students conducted.
Lordship, I'll explain. Please explain. Lordship, may I then have your attention once again that on the plot number NW74B, Vaidari constructors have already constructed a luxurious project. Lordship, may I have now your attention on page number 8, Exhibit C of the mood preposition. Exhibit C, page number 8. Seven, 8 in overall, Lordship. 7, it starts on Exhibit C, Lordship. Firstly, Lordship, I would like to observe that the period covered, that this phase of internet email were recovered between 10th of February 2023 and 2nd of March 2023. Lordship, in this email communication, there was integration of NW72 layouts with Vaidari height in the following email correspondence, and instructions were noted in Exhibit email C that shows instruction to ensure nothing lacks early coordination. Email to second line. Nothing that lacks early coordination. Email to second line. Nothing that lacks early coordination at this post for audit.
Nothing post.
Yes, Lordship. So now, Lordship, and also, Lordship, this means that you should be so subtle in doing your work that it further goes for the audit. There should not be any discrepancy which can be seen over here. That why it has been correspondence. Now, your Lordship, I would like to have your attention with respect to this to exhibit number 8. Yes, sir. Exhibit 8, page number 4. This notification states that the declaration of recognized slum under Section 302 of Vidya Prachar Slum Redevelopment Act. Your Lordship, if you refer the date, that is 12 March 2023. The land has not the start of the exhibit. So notification and fifth line of it. The notification has not yet been issued. That is, notification was issued for a land to be slum was dated 12 March 2023. And on Exhibit C, the email correspondence between Vaidari Constructors Private Limited and MCBN shows that they are already corresponding with each other for the development of the plot from 20th February to 2nd of March. Correct, Lordship?
At least prior to the notification.
Prior to the notification, even before the land was declared as slum. Till now, it is not yet gone for the redevelopment process also. Prior to the land to be declared as slum, they are already in communication with each other for the layouts and other processes.
This correspondence between Vaidari versus
this corresponds between Vaidari Constructors and MCBN, Municipal Council of Vidya Prachar. And the land has also been declared as slum with Municipal Corporation of Vidya Prachar.
Okay, but there is the declaration under this, because according to this declaration exhibit A, the land declared is plot number 74B.
Yes, Your Lordship.
And your construction happened in 74A.
No, Your Lordship. Construction happened in
74B. Where is that? Exhibit C.
Exhibit C, Your Lordship, page number 8. Just suppose that we can integrate the existing layout plan of NW74B.
It says. Please read the beginning.
Yes, Lordship. Once the notification is
correct, so that means they came over here during this correspondence between February and March. They are admitting that the notification has yet not issued. Once the notification is issued, means they are not hiding anything. They are admitting that the notification is yet to be issued. Once the notification is issued, we can integrate the existing layout plan of plot number 74B. What's wrong with it?
Should I acknowledge this fact? But the attachment which was given earlier to the email chain is of NW74B.
74B's notification.
What I'm trying to figure out is that the land is not yet considered as even slum.
Correct.
The notification has not been issued. Even before that, there is an integration of layout drawings.
Yeah, please demonstrate. That's what I'm saying. So it says once a notification is issued, we can integrate. That means this chain of emails is just at the planning stage. They have not given the 74B to the construction. They said once it is declared notification is issued, thereafter we can integrate 74B. If you have anything else to say, show me. This is not impressive.
Lordship, page number 7, there on the email chain summary, we have the attachment part, that is email chain summary 5th time. They have already attached a layout of NW474B.
What's wrong with it?
Lordship, what I am trying to say is that the slum, the area has not been declared as slum. So, even though the land is not declared as slum, they are prepared with the layout early in coordination with NW74B.
Is there any law in the law? Show me any law where you can't have a planning. See, I will take an analogy. If you purchase a plot of land or you're planning to purchase a plot, you have entered into an agreement for sale. You have not yet executed a sale deed. You just had an agreement for sale of a plot of land. You took your architect to that plot and said, this is the plot we are purchasing, we are intending to purchase, and we want to build or construct a bungalow. Similarly, this is layout plan is what's wrong?
Consider this point of view, but our conclusion is that why only one time constructors of even is early.
That is a different point. That you said initially that Vaidehi construction got preference over other competitors. That is one point. Then you shifted to the point that Vaidehi construction has been given that contract even prior to notification. That is what your point was, that correspondence is between February and March. Whereas notification comes on 12th March. So you say that how before notification came, this correspondence, or you're trying to smell some rat into this correspondence. See, there are 2 points which I am gathering. Correct me if I'm wrong. If your point of contention is that the lady is given preference over other competitors, that's where your Eroyappa's judgment you are citing 14, Article 14. Equality is not being followed by the municipality. The second point which you are alleging is that they are so much in a hurry that before notification they are allotting the project to them. This is your second point.
Second, you are very much correct with the first point. The second point, I am stating that they are not yet awarded the contract. What they are doing is that they are already in talks with Virgin Consultants Private Limited in consideration with planning. But why?
So your point is before allotting the contract, they are planning with Vaidehi.
Yes,
that is your point. Okay, move on.
Lordship, owing to this, such predetermination renders the subsequent procedural compliance illusory and constitute a clear violation of procedural fairness. Lordship, the council would like to humbly state that the conferment of.
Can you suggest that whether there were other competitors other than applying for this contract?
I have another question. This is a digital service development. That means municipal corporation goes into any development. There are a number of bodies who have been involved. But considering only Validity concepts for any reason in the MCPL notes was beyond a consideration. If would have been floated normally, then we are planning or the notice would have been given. The number of people would have come eventually.
And they should have entered into correspondence with all others.
No, sir.
Why only wedding?
That's a proper process would have followed. Therefore, India received notice for planning from various contributors. Then MCPL would have followed a necessary committee or whatever for selection basis on what their qualification is, their criteria, and they would have gone with the planning ahead. Because one option when a tender is being floated, let's suppose I am
several bidders.
Tender, no, I'm not going on to tender. I'm going to process. What we are saying is planning. Let's suppose a tender is being floated. I am looking a tender. I have to answer to my seniors why I am using this tender at what cost, at what level, and what is the consideration. For that, we require planning. We have acknowledged your option. I agree with that. For that planning also, why only one particular building was taken into consideration? It's a government property. The land is also government. It was not a private land. If it was a private land, then people have a different. Land was government. So for planning also, let us consider others. Let's then have their inputs, and then we can find out whom to go with ahead.
So your first charge is that the fairness has not been
followed.
Point taken. Next.
Yes, sir. Lordship, owing to this, I would like to state the case of Ramana Dayaram Shetty versus Airport Authority of India. Page number 20. Page number 27. 20? Yeah, I have for the mark. Lordship, this overall summary. Lordship, I read the father. I have a list of Indian companies has been given access to access.
But then why haven't you downloaded the full? Because only page 2 to directly 19 and 20. Anyway.
That's how I read the father.
In actual courts, don't do this. Because
unless
the full judgment is there before the judge, he will not consider you because this is like picking and choosing and selecting whatever you want to project. Now, suppose in this very judgment, there are certain pages and some paragraphs which suits the other side. You are hiding that aspect from the judge. The other side will object. So this judgment cannot be considered as unless it is in the complete set. Anyway, what is paragraph 10?
Page 27, right? That overall, if you summarize the lordship, like you have stated, that when the state enters into contracts or deals with the public property, it cannot act arbitrarily and must ensure equality of opportunity to all eligible bidders. In the lordship, I would like to move ahead. In the present case, now I'll link the whole slum development process to the tendering process. In the whole case, the tolerance of encroachment, unofficial extension of city canalities, and subsequent declaration of area as slum reveal the calculated sequence of action designed to facilitate redevelopment by a pre-selected private entity. Such conduct demonstrates that statutory power was exercised not for the benefit of slum developers but to confer private advantage upon Validity consumption. Lordship, for this, I would like you to move to page number exhibit B. I beg your pardon, Lordship. Prior to that, also, page number 32 of the moot preposition, there is the statement of Mr. Amitabh Rao, recorded before Chief Metropolitan Magistrate. Statements of facts by deponent. 8th line. Sorry. 9th line. On March 2023, a meeting took place at Vaidai's head office, attended by Mr. Devendra Vaid and two MCPN officers, one of whom was introduced as Rajiv Sharma, Deputy Engineer MCPN. Lordship, now I would like, with correspondence to this, I would like to have your attention on Exhibit D. That is page number 6. Now, Lordship, the planning process has been done. Now, term has been declared as a land has been declared as a sum. Now, this immediately corresponds to the between Municipal Corporation of Vidya Prachar and Samiti Private Limited. On the very first line of the bill, As per the verbal discussion held in presence of Additional Municipal Commissioner to 18th April 2023. Lordship, they have issued a letter, now an official letter to MCBA that we are taking your input for the draft end. However, they are not being opaque here as well. They have had a meeting at the Office of Military Constructors on 5th of March 2020. Whatever consideration or talks they had over there are not being even recognized or even not pointed out in the official notification which they have given to them. That with respect to this, we are issuing the draft. So what we are stating over here is that overall process was not even kept transparent to the public or others, even though the tender was a government tender.
It was to say that this exhibit B is emailed by whom?
Emailed by Municipal Corporation of Nagar and to Validity Constructors. Subject is draft tender inputs for slum redevelopment project. They are now seeking and permission request to Validity Constructors that we are giving you a draft tender to evaluate based on your technical criteria. A draft tender, if you go through all the
email to Greg is the
Managing Director of Validity Constructors Private.
Okay. So the Municipal Commissioner is writing to Mr. Greg
On 20th April 2020.
So what is the point?
Point is that on the mail body he has given reference to the meeting which overall verbal discussion ended on 18th April 23.
Between the Municipal Commissioner and Mr. Greg.
Mr. Ray. But he is not giving the meeting which has been held in Validity Constructors Private House on the 5th of
March.
Yeah. So that opacity has been maintained. They are not being transparent about what discussion they have. This is a government tender. Everything should be open and out to the public. So this has not been done. So this is my other contention. Amitabh Rao, Your Lordship. Amitabh Rao is an internal auditor who was working with Validity Constructors Private Limited. Yes, but
He stated this.
yes, Your Lordship.
He stated this in examination. Of course.
Lordship, he has given affidavit.
So this is examination.
Yes. Yes.
So he is admitting that in his head office, the Commissioner office to Central and Hector had a meeting. But please read point 9 of this.
On March, a meeting took place at Validity head office, attended by Mr. Devendra Bhai and two MCBA officers, one of whom was introduced as Rajiv Sharma, Deputy Engineer MCBA.
Contradicts this.
Exhibit B, what I'm saying is that Exhibit B mentions the earlier correspondence between them on 18th of February.
Yes. I'm just asking point 9, which you invited my attention. This or this Exhibit B. Exhibit B categorically talks about declaration. Sorry, Exhibit B saying that what?
Actually, I'm saying that they have been kept, not been transparent in whatever communication they have had.
No. This Exhibit B is in respect of what?
This is a draft tender inputs which MCBA is seeking from Validity Constructors Private Limited. A draft tender input as a part of pre-bid advisory framework which they are stating.
Draft tender notice in respect of what? In respect of 74B, where is it?
And the subject only of dot end up to 74. For 8 lines, subject draft tender inputs dot exhibit B, draft tender inputs for slum redevelopment proposal dot end up to 74.
Correct. Now read point 9 is 22. There a meeting happened between Mr. Baird and Rajiv Sharma and JL.
On 5th March, a meeting took place at Validity head office, attended by Mr. Devendra Bhai and two MCBA officers, one of whom was introduced as Rajiv Sharma.
Where is 74B? So how do you connect that this meeting was a 5th March meeting was in respect of that law? It can be any other thing.
Rashid, they already have an earlier email correspondence which I have stated as a part of it.
Email I might taken, I have jotted it down. Now this point which you are raising, that Mr. Rao, in his evidence in chief before the magistrate, stated that there has been a meeting at the head office of Validity between two principal officers. Where is this that? Why did not you during cross-examination point out? ये meeting किस बारे में हुई थी? ये कहाँ है?
Roshan, I have Roshan, on the 10 points.
In your office, you have a researcher?
Yes, Roshan.
Who's the researcher? Is this researcher?
Yes.
Surprising that this point does not have 74B?
No. So what it is not matching the deadline. The dates which are prior to these love declarations and their conversation, communication, like in which is stated in Exhibit C. This all days align with each other. So the last email which we can see between this Vaidai Construction and Rajesh Sharma, which is it is stated on 2nd March 2023, and then yeah, Exhibit C, page number email number 3, page number 8. Here we can see that it is dated on 2 March 2023. And then they say that once you confirm, we can have the official architect's upload and approved version. And then on page number 32, it's directly on point number 9, which you are stating, my lord. It is dated on 5th March. There are official meetings now. So this all, yeah.
That in the examination in chief, plot number has not come. So during cross, he could get it verified. Otherwise, this is lopsided.
Yes.
Isn't it?
Yeah.
You should have assisted him on this point that this is 32, the point number 9 does not talk of this meeting in respect of 74 pages.
So he just trying to connect the dots.
Right? You tried your best. I'm impressed with your efforts. But what I'm saying is not convincing to the court. See, Validity Construction is a construction company. Admittedly, yes. And municipal corporation is also having multiple land pieces, not only 74B.
Yes.
They are in ongoing businesses. There can be discussions about other plots also. So unless you crystallize it to the court that this 74B had happened on 5th March, and then in 18th April meeting they are saying they are hiding this 5th March. May be possible that 5th March meeting is in respect of some other plot or some other project. Is it not possible? Sir, I'll consider your dots. Okay?
Okay, sorry.
Very good. I'll take your dots. Be connected and do them. क्यों मिले थे आप? Sir, no, hold on 2 minutes. I'm just trying to bring it to your notice. आपने cross-examine किया था Mr. Rao को नहीं?
Not yet.
Not yet. बुलाओ उनको. Cross-examine क्या है? किस बारे में मीटिंग हुई 5 मिनट? नहीं, आप करिएगा मैं तो आपको बता रहा हूँ कि आपके डॉट्स जो हैं अभी तो क्या है जो आप करेंगे ना एक्चुअल फैक्ट्स तो कनेक्ट नहीं है ये सब इनकी तरफ जा नेक्स्ट
This I want to talk to the Roshan that there was no opacity which was maintained between Vaidai Construction of opacity means there was no transparency which was
actually this opacity
no transparency which was maintained between this for this government entity. Also, Roshan, further I would like to say that welfare administrative discretion under the Act is a public trust and must serve the public interest. The Maxims Salus Public Supreme Law is the welfare of the people is supreme law. State that the people's welfare should be considered. Over here, the Vaidai constructors with the overall aligning has been in such a way that the tenders will go to Vaidai constructors private limited leaving aside the slum development. Why we are stating this? Because Vaidai has already considered a constructed a luxury building design. They already have the input of manpower. The materials must be there easily available. Transportation will be easy for them as they are already input into them. So getting this land from the government and helping them to construct this will have a monetary benefit more to the private developers rather than slum developers at the very first point. Hence, Vaidai constructors was given preference and which was against the Article 14 of our Indian Constitution. If you are with this and Lordship, whether the procedure adopted by Special Investigation Commission reveal bias or procedural irregularity sufficient to create the fairness of findings that it has been considered. Lordship, firstly, I would like to state here that respondents have also agreed to the fact that the SSC commission which was formed unbiased. Firstly, this was given the direction by the High Court. Then the retired Supreme Judge. I would like to have attention on the exhibit page number 9. Yes, sir. Page number 9. The committee was formed between prepared by Justice retired A.K. Vashishkar. Members were the Executive Committee of IS, retired Executive Team of Lordship conserve members starting part constituted by date, commission, chair, members. And Mr. H.P. Jaiswal. The SIC was constituted because of the technical and administrative expertise of these members and these members only. So this is what we are stating. SIC is completely for it is in the true in nature. Furthermore, SIC is conducted in part in very good way as well. On the page 9, on the last paragraph itself, it states that the commission conducted proceedings over 7 months, examined 43 witnesses, considered 87 documentary evidence exhibits.
It's wonderfully prepared, constituted out there. What is the report?
Report states that the commission several irregularities has been found. Lordship, I'll have to come to page number 10 of the moot proposition. Firstly, pre-tender layout approvals, exhibit D. Pre-tender layouts approval, which was there, preliminary technical clearance according to what they plus.
You never did.
Of moot proposition. Finding 3.2. The first irregularity in the project negotiation. Lordship then yes, sir, also financial activities. Then exhibit 5D5.1, page number 11, procedural conduct of municipal operation officer. Inappropriate level of informal engagement. Lordship, there are and it was further recommended to SSC and SFI. So what we conclude with this slide, and I agree with this one, respondents are also agree with the SSC was contributed by XP. But the procedure comes, we are seeing that this one unbiased. Pardon? Unbiased. Unbiased, and whatever findings which SIC has constituted during this whole process is valid, and further recommendation has been given to SFI and SED to carry out the further reports. And which is, I would like to conclude the issue number 2 as well, that for agreeing to this SIC report cannot be discarded and should be considered for the further investigation process as well. Which is, I would like to state that who are you? We are representing the petitioners over here. Yes, which also we are given for Ranjit Nagar Rights Forum. And then
no, who's the there? You're the one.
it's an NGO lordship. There are actually 2 cases which have been combined. Yeah, I start here.
In your introduction, that who are you?
From NGO.
You are the IL some NGO was
Yes,
part
sir.
of this PI exposing this corruption between Validity and Respondent.
There is a shutter right for him. Yes, sir. Owing to this, we are saying that this SSP report is valid and should be considered further. For any further number 3 and 4, this will be directly linked to the SSP.
So what happened to the
Recommendations have been carried out for the ED report has been taken into consideration. ED has conducted their separate research. Even SFI has done a survey research, which will be further explained by the relevant co-counsel in each number of years. With this, I will actually consider.
Issue number 3 deals with whether constructors and its alleged association with public officials constitute criminal conspiracy and money laundering offense and attract certain provisions of Bharatiya Nyaya Sanhita. Your Lordship, it is my request that I would like to state my issue number 3 and 4 together as they are in connection. Much obliged, Your Lordship. Your Lordship, firstly, I would focus on the money laundering part. Your Lordship, if we see the definition of money laundering, there are considered two things. One which is proceeds of crime, and other is scheduled offense. If the proceeds of crime are under scheduled offense, then this constitutes money laundering. So, in the given case, the railway constructors and the offshore transactions between are constitute proceeds of crime under scheduled offences, and that's why they should be held liable under this uh, Prevention of Money Laundering Act 2000. With reference to this, I would like to draw your attention on exhibit number J, Your Lordship, which is the Enforcement Directorate. In any transaction, Your Lordship, which in relation to money laundering, there are three stages, which is placement, clearing, and integration. The transactions between railway constructors and its alleged companies, that is Crystal Global Limited and Northway Holding Private Limited, and then the same remittance uh, back to India in Vaidehi, along with uh, along with remittance to Mrs. Sushma Sharma, who is wife of Mr. Raju Sharma, who is MCBN official, constitutes who is deputy engineer of MCBN, constitutes the placement clearing integration topology under financial action plan. Usually, this is a common way of money laundering, Your Lordship, wherein shell companies are created, and from that shell companies bear accounts of foreign bank accounts, and from them foreign bank accounts by layer on layer. Funds is transferred from A company to B, B to C, and then again from C to A, and that is how the funds are routed. So this constitutes round tripping of funds, Your Lordship. If we
what are you writing as Exhibit J?
Yes, Your Lordship, page number 27 to fund flow analysis, which is yes, the enforcement directive.
Table.
Yes, the table fund flow. This is the placement, clearing, and integration of the amounts happened between Railway Constructors Private Limited through two shell companies, and then remitted back to India to Railway, along with yes.
First
First
point is
point is placement from Railway.
Crystal Global Singapore
Yes.
18.6.
Yes. 18. Then
Crystal
the Crystal to Northway Holdings Private Limited, layering in entity account for second
Northway Holding Private Limited transfer via two immediate accounts Swiss National Bank Singapore.
16.2 crores.
Okay.
This is we are two intermediaries. One is Crystal, second is Northway. And the integration is that Northway in June, October 23, 12.7 crore. Again, the funds are credited back to customer. And and this happened in a period of within 6 months.
Yeah. Is this report says the money trail is between these three companies?
Yes.
So, routing,
Yes.
this is the same money. Or they have some contract other than this between Northway and Valley.
Your Lordship, if you notice the dates, and if you come to our memorial chronology part, which is on page number 13 of our memorial. 30. Uh, 13. 1 3.
One. What does it say?
This entirely relates to the project development of plot number 74 of all the events which has happened. Your Lordship,
Where do you find this chronology?
we have read all the exhibits and we have aligned the dates how this actually transactions happened, because money laundering transaction does not are not computed
This
directly.
is your creation on the basis of
Yes, yes, Your Lordship.
study of
Exhibit and book.
this is your creation.
Yes, yes,
Chronology
sir.
of events.
Yes, sir.
And what is the finding of this chronology?
That there is money laundering and criminal conspiracy created between Vedic consultants and Singing.
So one point you have established that the money was routed from Delhi to Singapore to this to that and back to Delhi.
Vedic. Along
But your counsel has stated that it has also gone to the wife of the commissioner. Where is that?
wife of Commissioner, not
Ramesh
Commissioner,
Sharma.
Ravi
From Sharma.
Yes.
So where is that?
I
That
have-
trail is also some table is there.
I said along with 12.7 crore, within 2 weeks of that foreign remittance, 18 lakhs were transferred.
So where is that?
Page number 27.
There is
That
one
exhibit G, ED report.
G.
On the same page, below that table, your
J or G?
J, J,
J.
J,
And
Below that.
release that 18 lakhs into personal account of advance from within 2 weeks to foreign credits.
and the proof is that on the next page, it is transferred from Crystal Global Limited, which is the layering company in this transaction.
No. My question is, this 18 lakhs is paid to Mr. Sharma by whom?
By Crystal Global Private Limited, which are self on the next page itself.
So, Crystal was the recipient from Northway. Northway.
No, was sender. From Vaidai to Crystal, Crystal to Northview, Northview to Vaidai, along with the Sushma Sharma.
No, Crystal is directly linked to Sushma Sharma.
Yes, Crystal.
So, in between Northway is White House.
Northview is white, but 12.7 were passed through.
Who knows where is that?
Layering
Last
in
point,
layering.
bank analysis released 3 deposits.
In layering, Your Lordship, the 18.6 crore is passed.
Where is that?
The table of fund flow analysis.
Your
No, fund flow analysis in
Yes.
report.
correct. 1, 2, 3.
In that second point, layering, Crystal Global Private Limited shared it to Northview Holdings Private Limited.
Correct. Which in turn paid to Valley.
Vaidai,
Paid to Valley.
Vaidai and Crystal paid to Sushma Sharma.
But this directly paid to Sushma Sharma 18 lakhs. That's what I'm saying. In that deal between Crystal and Sushma Sharma, Northway is sideline.
Yes, yes, yes.
Where Crystal is directly dealing with Sharma, whereas Crystal with Valley is in between Northway. Correct?
Yes,
So, this Sushma Sharma dealing with Crystal, the investigative agency did not find any connection between Sushma Sharma with 2 payment platforms.
she was neither employee or lordship, neither she was.
Correct. That's what I'm saying. They could not
Yes,
find any linkage between payment platforms.
yes, Your Lordship. And plus she was spouse of the deputy engineer Rajesh
What
Sharma.
does she? Is any worker or something, some consultant to qualification and system?
No, it is not.
It's just also. We are using
Secondly, your lordship, this Crystal Global Limited, the payment were transferred on the note of consultancy MCD in placement in the same payment description. Payments to Crystal Global Limited Singapore under consultancy MCD project. And yes, and same Crystal is transferring the two NCVM officials file 18 lakh rupees.
So you are connecting the dots that way.
That way, as well as here. Here, this comes primarily to the public servants and spouses direct related.
And she is not any consultant, not qualified consultant or right?
Her professional association with the firm is missing from Crystal Global. Your Lordship, first, this constitute proceeds of crime under scheduled offense. Scheduled offense.
In which section?
Your Lordship, section number 3 of the Prevention of Money Laundering Act.
3.
Whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a part or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession in our case, acquisition or use and projecting it as consultancy revenue, or claiming it as consultancy revenue against the veterinary constructors as its untainted property shall be guilty of offense of money laundering. In the AOA, in the SFIO report, Exhibit I, Your Lordship, page number 25. Finding 3.1, offshore remittance without board sanction were given. Their articles of association permits that only 50 lakh can be given without a board resolution. Without passing a board resolution, they have remitted 18.6 crores, and that 18.6 crores, if you link the date, that date is when the pre-coordination of tender layouts between NCBN and whether constructors were going.
No, so what's your point?
Which means weathering constructors very well.
Mandate explicitly says 50 lakhs. Here, article of association.
Yes, of that company. Yes. That is there in their articles of association.
There is the article of association.
That is mentioned.
But then, is it mentioned in the proposition?
No, that is not mentioned in the proposition.
Where do you get this 50 lakhs?
These are the key findings of SFIO. SFIO is SFIO has verified it as
That's what I'm getting at, that whether this SFIO's finding of 50 lakhs bar of varying construction, is it in the proposition?
no, it is in the bank account statements and the board of directors report, the methodology used to investigate.
No. I'm simply saying. Your point is that the Delhi's article of association state that foreign remittances without board approval is up to 50. If it is above 50 lakhs, they should be approved by board of directors.
Yes.
This point is picked up from there. Is this your imagination, or it is in the proposition that the board limit is 15 lakhs?
It is in the proposition page.
Correct. That's what I'm saying. Where is it in the proposition? Invite my attention to the
Page number 25 is the key findings.
That's what I'm asking. Where is it? Number
25 allowance.
25.
Finding 3.1. Line number 3. The company's articles of association mandate explicit board approval for foreign consultancy evaluation executive plan.
Okay. This is already in the proposition.
Yes.
And the proposition says that because the mandate was 50 lakhs and they have transferred 18.6 crores.
And if you look at the amount, it is 1/3 of the projected income of the estimated projected income of the tender. Which is Exhibit A. Pardon the lordship, Exhibit B, page number 7, clause 7.1. Line number 2 from above. Which is
64.2 crores.
which is almost 1/3 of the amount which has been transferred.
That's the allegation letter.
Allegation is this is the routing of funds.
No, why 1/3? 1/3, you are inviting my attention to 1/3 of this routing. So, please justify why 1/3 and what is the purpose of this 1/3? They are trying to.
Whether he wanted to raise this tender in any way. Secondly, bribery was paid to spouse of auxiliary.
1/3.
18 lakhs of three deposits of 18 lakhs, which amount to 54 lakhs. Plus,
0.6 crore.
that's where bribery comes into picture.
Correct. So, this is your allegation. See, I
They very
understood.
well knew that they are doing such foreign remittance, even though they are ultra vires their own articles.
Maybe. Please tell me the objective of this routing.
Because they wanted this tender and because they wanted to redevelop the 74B plot.
Point taken. Where is that 18.6 crore utilized, which is routed as per SFI's report? Out of 18.6 crore, 54 lakh is paid to Mrs. Sharma.
Yes.
Where is the rest of the money?
Rest of the money, some was paid to again Rajiv Sharma in the name of Crystal Global.
You mean to say that Rajiv Sharma owns this crystal?
Yes, sir.
When did you say this?
Your Lordship, this is the interim report.
In your arguments, you did not say that crystal is owned by Mr. Sharma.
Your Lordship, even Amit Rao, who was the deputy, who was
Amit Rao is the one who paid.
approved. Yeah. Mentioned that Rajiv Sharma was on 5th March on that in Vedai's office. Secondly, in the placement, it is under consultancy engineering project, and that same company remits. I'm just linking the chain of circumstances. And that same company remits, Crystal remits Sushma.
What I'm saying is, my question is, do you
There
have
is not explicitly mentioned that Crystal Global Private Limited explicitly belongs to Mr. Rajesh Sharma. I am seeing on the basis of chain of circumstances.
That's what I wanted to know that
Yes.
crystal का Mr. Sharma से connection कुछ established नहीं.
This all
Maybe even if it is not owned exclusively by him, it is part of that, or if it is a board of directors or some kind of segment. You haven't established that.
Your Lordship, I have noted your Lordship. Further, with this context only, this whole deliverables and service reports were produced out of fake invoices and backdated invoices, which is in on page number exhibit G, point number 2.
and verification.
Your page number 19, point number 2. Contains unsigned copies of service agreements with Crystal Global and Norway and point number G, contracts overseas PD. This is the external hard drive recovered from Bitcoin. It contains unsigned copies of service agreements with Crystal Global Private Limited and Northway Holdings Private Limited. They're unsigned and there is no seal on it. And plus, even the internal auditor has acknowledged this. With respect to Crystal Global and Crystal Global Private Limited and Norway, who are the actually nominating nominee of that company and the Singapore companies. Further,
is nominee of Crystal.
no, the directors, who are the directors, we have the ED
You
has
have the names of the directors of Crystal and
no, we have sent a letter. The ED has sent the letter to MA Singapore, and still it is pending.
we don't have any.
Yeah, it is in process of election. We'll soon receive.
We go premature. The petition is premature. You are still in the process of getting the evidence.
You
Why
actually
don't not all? I got the point.
Indian banks, we have got it from Indian banks, which is the Axis Bank, and based on that, we have continued the processing. Still, the process is
The investigation is going on.
going. This one.
So what do you want from this court?
We have found material evidences, Your Lordship, which constitutes money laundering offence by violating.
What your points
And
are all
also-
taken. What is your relief you want from this court?
We want to take down the tender awarded to Validity and the notification which was given, which was of development of service, which was awarded.
For the,
Yes.
so what is the final relief you receive from this?
Our final relief is that SIC procedure, the procedural irregularities by SIC was noted, and the report is unbiased and valid, and the tender of given to Validity should be forged, and the notification should be set aside. Plus,
Notification
Notification.
declaring that 74B
is a slum development
that
that
should
should
be
be set aside. Plus, reinvestigation with respect to death of Rohan Mehta should be done. Because this connect,
Supreme Court is very
yes, that's what I said. I'm linking all the things with the death of Rohan Mehta. So I said issue number 3 and 4
now
will be linked with it.
it is informed what happened to him.
Yes, Your Lordship. Rohan Mehta was the independent
No,
concern.
what the police find in one methods.
Police carried out the exhibit E postmortem report. In exhibit postmortem report, there is a huge gap and questionable time of death of Rohan in proposition P number 2. Rohan Mehta died on 12th of June in his apartment. Further, in exhibit E, police sent the requisition request for postmortem report on 13th June at 22:10, which is at night 10:10. But the autopsy report, page number 14, the next page, confirms that the approximate time death is 8 to 10 hours prior postmortem examination.
Comes in this sequence.
12 June, Rohan Mehta was found dead at his apartment, claimed by police officials. Next is 13, the police official sent postmortem requisition request on 13 June 10:10. And on the autopsy was conducted on 14 June 10:30 a.m. in the morning.
Correct.
But
13, 14.
there are 2 days, that is more than 48 hours. But the time of death is 8 to 10 hours prior to postmortem examination, which
That
is
means He died on 14th or 13th.
Yes, 14th night, around 12. Or maybe from 11 p.m. or 13 to 1 a.m. How come a alive person's requisition can be given by police for postmortem report? And apart from the mode proposition given, there is nowhere mentioned the time of death and time of death. In the mode proposition,
Date of death is
only days.
Date is 12.
12.
Time is not given. But even if time is not given, according to you, the autopsy report says that he must have died between the night of intervening night of 13th and 14th, not at all at 12th.
Yes, yes. And despite this, police has closed the case within 15 days.
No, but the body was found on 12th. No, you said.
That is claimed by the police officers.
You need to say body was found on 13th or 14th.
He was alive on 12th of April. This is what
You meant this. The police declared him to be dead.
this is all
Cover
conspiracy.
up.
Yes, even public officials are involved. We can see MCA
So
officials.
means he was alive and he was killed.
Yes, Your Lordship. And this requires further reinvestigation, Your Lordship. Because the police officials only closed the case despite the postmortem report was not conclusive, Your Lordship. Your Lordship, in
This
the
is your prayer. The
for reinvestigation.
investigation of Rohan.
Since the medical findings were inconsistent with this.
And what does the charge sheet say? The suicide.
Charge sheet has not yet been
Not
filed.
right.
With respect to unmentioned death, yes, they have declared the case closed.
Declaring what? Suicide.
They have closed the case, Your Lordship, declaring it as yes.
Suicide, not suicide.
Right, yes. Your Lordship, the toxicology reports states that there are sedatives found in the body of the deceased, which is the lorazepam.
Otherwise, what was the mode of suicide?
Otherwise,
What was the mode of suicide?
we
Method he committed suicide.
by handling
By
nylon,
handling, not by poison.
not by poison. This has to be reinvestigated because ligation ligature mark is there of nylon cord, which whether it is ligature strangulation, whether the ligature mark is due to hanging, or whether it is the death is because of lorazepam, we are not yet. The report is not conclusive yet. The
The police report says that the suicide is through hanging.
it does not conclude. The postmortem report is not
That
conclude.
was the postmortem.
It is
What
the
the FIR says. Happened is later.
FIR is not precisely given.
Anything must be there that he committed suicide by hanging, or by poison, or by what?
Your Lordship, just it is mentioned that they concluded the case within 15 days. And in Exhibit E postmortem report, the deceased was reportedly found hanging from the ceiling fan using an nylon cord. Yeah.
That is the postmortem report.
Yes, sir.
Okay, and then you said that the postmortem report also says that there are sedatives found in the body.
Yes. Ligature mark is incomplete and atypical with suicidal hand.
It is suicide.
Yes, lorazepam.
If a person is sedated, how can he act?
That is what our question, Lordship, and
That is
that's
what I am very convinced about your argument.
much of the
I will definitely put an inquiry.
much of the
Who is the policeman? नहीं आप कॉल में उसी को हैंड करो.
Your Lordship, further, Rohan was independent president of railway constructors. Exhibit G,
He is not employed.
He's not an employee. He was independent constructor and his work was to advise.
So, how do you make this suicide with this?
Yes, Your
conspiracy?
Your Lordship, the exhibit G is the hard drive, which was given by Rohan Mehta to her close friend Ananya D'Souza, which is a witness, and Ananya D'Souza later produced that hard drive in the court. That external hard drive reveals certain transactions between Mr. Wellring, that and this all is recovered from the external hard drive. This placement, really, FAST topology transactions, that is revealed from that external hard drive.
Why did he commit suicide? Was he involved in something and he was afraid that it will be revealed in an investigation? Why would somebody be an independent consultant commit a suicide?
Your Lordship, he extracted that hard drive and kept a private backup. And later, a whistleblower released some documents, and when wealthy constructors came to know that it is three people, Mr. Rohan, the internal auditor Amitabh Rao, the MCBN official Mr. Rajesh Sharma, and wealthy constructors. When they came to know about this, they started. They started pressuring him, and he was in distress. Yes, pressuring him to prevent this call layering
this dissemination of
that this all conspiracy should not come out. Which I state with respect to that the state Rohan was murdered to prevent disclosure of incriminating
you allege that it was not suicide, it was homicide.
Yes.
And by Rajiv and
Wealthy constructors and some unknown officials on MCBN.
We all conspired.
Yes. And further, the investigation is needed.
So, you wanted Ganesh to be investigated or closer?
No.
Suicide की case की close कराया है
Yes, sir.
manipulate करके.
Yes, sir.
Allegation.
Yes, sir.
Anything else?
Your Lordship, this exhibit G, which was given to Ananya D'Souza, he prior to death, just 3 days before, when the alleged death was declared, that is of 12 June, gave it to Ananya D'Souza, stating that someone is following him, stating that they know I have seen too much and I am being followed, stating that if something happens, Ananya, make sure this story doesn't die, it's just not about me.
This story?
Doesn't die, it's not about me. It's just not about me. Which means there are other people involved.
This is stated to her.
And
He is not definitely suicide.
he has left a suicide note wherein it states that in exhibit F your lordship, it ends where it began and I cannot be fighting for this. Yes, your lordship. Means he was under emotional distress, your lordship.
This one line.
This is the suicide note of.
One line.
Yes, your lordship.
It doesn't look more fighting with whom?
Your lordship, for this ongoing all transactions and sudden
It's not just jotting the point.
Yes, sir.
This nowhere leads to say that I can't keep fighting with Vajayis or.
Thus, this requires further reinvestigation, your lordship, to conclude.
अब वो तो गए ना उनसे पूछे कैसे भी किसके बारे में कहाँ से इन्वेस्टिगेशन होगा
Lord Roman, death of Mr. Roman, that it was homicide or murder or suicide.
This line doesn't help, no?
He left a suicidal note.
It ends where it began. I cannot keep fighting this. This may be a kind of romantic angle also with some lady Is it impossible? I can't keep fighting. अगर आपका है कि नहीं possible? अच्छा, सबका divided romantic angle के लिए. Yes, yes. Anything else?
Your Lordship, this
Okay.
just 30 seconds. Your Lordship, I would like to conclude with this. With respect to issue number 3, this constitutes money laundering and criminal conspiracy, and the said financial transactions are not legitimate, and the death of Mr. Rohan Mehta is questionable and still requires reinvestigation. Your Lordship. Much obliged.
We are the counsel for respondent in the present case. The respondent seeks permission of the Honorable Court to
Who's the respondent?
where they the bench is your lordship. If your lordship is well versed with the facts, counsel seeks permission to directly start examine the issues. Your lordship, I will be dealing with issue number 1 and 2, and the counsel will be dealing with issue 3 and 4. Counsel seeks permission to whether the conferment of the redevelopment rights under the Vidya Prachar Samiti Development Act 2010 in favor of Vedai constructors violates the constitutional principles of transparency and equality under Article 14, or whether such conferment presents a valid transformative act within permissible limits of discretion. The slum declaration under Section 3, subsection 2 was a lawful and objective statutory exercise. May it please the Honorable Court, the respondent submit that the declaration of plot number NW74B as a recognized slum was made strictly in accordance with Section 3, subsection 2 of the Vidya Nagar Slum Redevelopment Act 2010, which empowers the competent authority to declare any area as a slum upon objective satisfaction that the conditions are hazardous to health, safety, or habitation. As evidenced by Exhibit A detailed survey dated 23 February 2023 recorded nearly 687 families, lack of sanitization, unsafe electrical connection, and substandard housing conditions.
Statute is the same which we meet with the Senate.
Yes, it is perimeter section 4. Subsection.
Section
4. 5.
4.1. please read.
Reading the water was given in book, which is also mentioned where the competent authority is satisfied that any area is or may be a source of danger to health, safety, or convenience of the public, or that building in such area are unfit for human habitation, it may by notification declare such area to be a slum. Importantly, lawful ownership or legality of occupation is not a precondition for
When the competent authority is satisfied, they can declare. Right? You began to the point that all the procedure and operating procedures have been followed.
yes,
So the satisfaction of the competent authority must be subject to some inquiry.
yes, exhibit A, page number 4.
Exhibit A.
Urban habitat itself had surveyed the area.
A.
Paragraph 3 and the said survey has certified that the inhabitants of the aforesaid area are dependent upon the informal
So that
housing.
happened in
The notification.
23rd February.
Yes. My lord, the prosecution stands and falls on
What we are is first concept. When architect is seen, that the correspondence began from 10th February onwards. See,
my lord, the prosecution case stands on electronic material, section 63 of BSA, lays down 6 statutory safeguards for admissibility of electronic records. In the present case, the device was not under lawful control.
they have not been realized
The data in that
63 certificate is not attached. This allegation you need to say goes.
For the email dated is now same over here. Invitation page number 9. Forensic verification extract. It states the verification authentic status as well.
Verification. What?
Of the email sent from vendors to corporate user.
Where do you get it
The moon preposition.
from? There are 9 forensic verification.
Page number 9.
Page 9. Report reference dated 12 August 2000.
Verification status.
It's 9.
So fourth line verification status.
94% confidence. Authenticity, huh?
Yes, sir.
No signs of post manipulation.
certificate was not for this.
Forensic will never be all. Certificates to ऊपर चले गए. Forensic is much above that certificate. BSA है आपके पास?
Notwithstanding anything contained in this adnium, any information contained in an electronic record which is printed on paper, stored, recorded, or copied in optical or magnetic media or semiconductor language which is produced by a computer or any communication device or otherwise stored, recorded, or copied in any electronic form. shall be deemed to be also a document if the conditions mentioned in the section of satisfied in relation to the information and competence.
63 is about the admissibility of a document.
In 63, whoever is about the same.
Yes, please read 63 more.
In any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things shall be submitted along with the electronic record at each instance where it is being submitted for admission deeming, identifying the electronic record containing the statement and describing the manner in which it was produced, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by computer or communication device referred to in clause A to E of
Now, A63 is to be read in the schedule at the end of case. Schedule is like
I don't want to.
really A64 is certificate is to be in this format. Schedule का जो format नहीं है, इसमें technical चीजें हैं सारी. Alright. They are saying these technicalities are verified by the forensic department and they found it to be 94% correct. That is as per the exhibit C, page 9.
Shall I continue?
That's the point.
Shall I continue?
Please.
Article 4 permits reasonable administrative discretion. Article 4 prohibits arbitrariness, not discretion for my argument.
On the point that there were procedural lapses in declaring it to be a slum. 74B to be declared as slum, they have not followed the procedure of slum. They followed? No? Sorry.
Lordship, that's what we are. That's what we are contending. That all the procedural.
Were followed.
Yes, Your
Not
Lordship.
followed.
Yes, Your Lordship.
But that's what I'm saying, that if they were followed, you referred only to section 4 of SC. It says that any area will be declared slum subject to the satisfaction of the authority.
Yes, Lord.
If the authority is satisfied. Right? Now, my question is that what is the criteria of this satisfaction? There must be some inquiry. How do you get satisfied?
Your Lordship, there is a survey conducted. Wherein the conditions are already mentioned in section 4 of the Slum Redevelopment Act. So the survey was conducted and those conditions were satisfied, and then that area was declared as such.
So the arguing supplying this information to whom?
Lordship, I addressed this point while that urban habitat cell corporation conducted a finding.
No, you did that. But what was the procedure when I'm asking? You have to explain me that the satisfaction must be subject to these steps. These steps has been followed, that's why he was satisfied. Am I making the point?
Yes.
जानिए सप्लाई करिए फटाफट लिख के नोट्स ये अलर्ट यू आर पार्ट ऑफ द टीम
First the slum
आईज आर ऑन क्या कर रहे हैं आप बैठ के सुनिए आप तो सो रहे हैं ना कंपेन पेपर की जा रही है सब बिल्कुल आपकी मार्किंग करने में
First, the slum notification was welfare-oriented, evidence-based, and within statutory bounds and cannot be labeled arbitrary. Article 14 permits reasonable administrative discretion. Article 14 prohibits an arbitrariness, not discretion.
the Constitution of India.
not sorry, Constitution of India.
Why does it say so much? The 14 is one line article.
Yes, I'm just
Interpreting.
no.
कुछ इंटरप्रिटेशन की बात नहीं है कोई जजमेंट है
In judgment in Tata Cellular versus Union of India,
how you see there is no judgment why do you have to do the form
the Supreme Court clearly held that the courts did not sit as appellate authority over administrative decisions, and judicial review was limited to
number
have highlighted.
so wait
Yes, 72. The judicial review is limited to illegality, irrationality, or procedural impropriety.
which paragraph
I'm not, this is also the
which paragraph of Tata
70. There are inherent limitations in the exercise of that power of judicial.
which paragraph
70,
70.
third line. There are inherent limitations in the exercise of that power of judicial. Government is the guardian of the finances of the state. It is expected to protect the financial interests of the state. The right to refuse the lowest or any other tender is always available to the government. But the principle laid down in Article 14 of the Constitution has kept to be in view while accepting or refusing a tender. There can be no question of infringement of Article 14. The government tries to get the best person or best quotation. The right to choose cannot be considered to be an arbitrary power. Of course, the said power is exercised for an equilateral purpose. The exercise of that power will be struck down.
this 70 is my point which Tata 70 is that satisfaction of the authority before notifying that this area is from must be not arbitrary, must be subject to some kind of steps or procedure laid down. You are saying that all the steps were adopted. Next,
No material has been produced to show that the discretion under Section 3, subsection 2 was exercised for an extraneous purpose.
section 3, subsection 2 of what?
Within the shadow slum.
That is sorry.
The mean fact that the
Section 3,
subsection 2 was exercised for an extraneous purpose.
3,
Section 3 sorry, for section 4 subsection 1.
section 1, then not satisfied.
That the religious marriage.
Correct. Where the competitive work, the point you already made.
Means that an outcome benefited a private developer does not convert a lawful act into unconstitutional.
Who said that SRA is unconstitutional act? Did you challenge the validity of the statute? You did not. Why are you saying that the statute is unconstitutional? Who said that? Getting my point? You are arguing something that some action has been taken and the areas where Islam
Act of declaration of Islam.
is not does not become unconstitutional. They did not say that it is unconstitutional. They simply said that the procedure is not as per the statute. In your case is that it is followed as per the procedure.
No colorable exercise of power is made up.
They did. That is the allegation.
The petition alleged that the slum declaration of colorable extract intend to favor Vedanta.
Correct.
The respondents respectfully submit that colorable extract requires a proof of a hidden collateral purpose, not mere suspicion. Here the purpose was clear: rehabilitation, safety, redevelopment. The object of the SRA.
But the building is not made. That's the building one.
You can do 74 weeks. So the building is
What is one? You are saying that you are going to make it a slum dwellers construction, not a luxury apartment.
Yes.
Next.
The involvement of various concept is therefore structurally contemplated by the statute itself. The fact that Vedic constructor later participate does not retrospectively taint the slum declaration. No evidence shows that statutory power on excise for an impermissible object. Hence, the doctrine of colorable excise is inapplicable. Pre-tender consultation do not violate the tender process. The petitioner rely heavily on pre-tender images exhibit B and C to allege favoritism. Urban redevelopment cannot begin in a vacuum. Feasibility studies, draft layouts, and technical inputs are planning exhibit B internal note. My note. It says that this communication has been issued as a part of the pre-bid consultation process under the Redevelopment Policy 2019. Yes, page 7. Internal note. And does not
Communication has been issued as part of the bid consultation process.
under the redevelopment. We don't have the policy with us.
Because this is the point. It demolishes the accused. This is true. इसका तो केस ही collapse हुआ.
Yes.
This is true because you are already declaring. You are this pre-bid consultation.
Yes.
All that email etc. are promisable. ये आप पहले से पता था कि सब pre-bid है.
Yes.
और bidding आपने after notification की.
Yes. Notification of supplied for the.
That's why thereafter you bid it. That's why it means among others. बाकी सारा consultation तो pre-bid. Protected है.
Yes.
Yeah, please.
Lordship is stated earlier also the timeline of communication and issuance of this letter. Legal communications were made prior to the issuance of the notification. And in this particular notification which they have issued, they have taken consultant only for a technical points which they have taken into consideration. If you can see, you can read the attachment of the document, page number 6, 6/9. The file which has been attached and given to Validity as a part of the bid is a draft tender file, and it contains only the technical clauses which are to be there, and they are asked to be verified by Validity.
नीचे कोई clause to put.
Eligible developers must demonstrate prior experience of at least one completed redevelopment project within 500 meters of the subject site.
It is not limited to Vedai alone. ये तो कईयों को माटा होगा. Draft tender.
Actually, nowhere it is mentioned that
It is not even mentioned that it is given only to Vedai.
Your Lordship, this exhibit B is shown as the formal communication between Vedai and NCB, while the exhibit C is prior to exhibit B, where in February they are attaching the same layout N474B, and then
This is only between municipal corporation and weathering construction.
yes or not, sir? And
But it's
exhibit,
video- slide that is attachment to this.
it is extracts from the attachment of draft tender notice. The draft,
नीचे 2.1 पढ़िए ना, eligible developers.
yes.
Developers must be many.
Yeah, it might be the case that there are many developers in the market with this, but why only Vaidai constructors are were taken into consideration for all this?
Yes, that's what I'm saying.
Exhibit C, same attachment, layout N74B, B2, so page number 7, attachment, email chain summary.
If you can link this to clause number 4.3
Attachment of attachment number 8.
Attachment, page number 7, email chain summary. They first discussed priorly with the welding constructors as to what draft and the notice should be given.
Sorry, but this is the exhibit C of your petition. Yeah, आपकी petition है ना, उसका exhibit C है. So you have picked and chosen the email correspondence of Vedri and Municipal Corporation. How do you know that there are more emails with other developers also? ये exhibit तो आपका है. आपने सिर्फ इनके बदला लेने के लिए इनका ही email निकाल लिया. बाकियों को आपने नहीं लगाया.
Why we are putting Vaidai constructors fully in the forefront of that? Vaidai constructors already have a learning which was going and they are completed. They are the favorable ones of
That is in 74A. Not number
yes,
74A.
74 they have
Adjacent to 70.
Correct.
they have
74B जो है, उसमें नया टेंडर जो आया है वो अभी अलॉट हुआ क्या वेदरिंग को?
yes sir.
उसमें नुकसान क्या है? आपको मिल गया? प्रॉब्लम क्या है?
It was opted in violation.
Nullified thing.
Yes.
Even I would just like to have the attention once again on the clauses also which they have been referred to. Given proposal to ensuring maximum rehabilitation density with minimal government cost. The Lordship, I'll explain this particular line what I proposal ensuring maximum rehabilitation. Military constructors have already utilized plot number NW74A in a very good manner like this project. Now, the plot layouts are also exceeding the emails earlier. Ensuring, which also states that boundary wall saves a lot of time about avoids dual infrastructure. So binary constructors in this point also has a very much advantage of ensuring maximum rehabilitation because they already have an idea of how the plot is, how the plot can be evaluated, already approved layouts.
But they are going to do the optimum use of the plot. Correct? तो उसमें आपको प्रॉब्लम क्या है?
Problem here is that only binary constructors are limited by taken into consideration.
This is favorite is a lot.
You are saying that because they have constructed a luxury building at the adjacent lot, this plot, if given to them, they can do the optimum use without putting a boundary wall or something.
No, we are not saying that. We are saying they will be in a beneficiary position if they get to provide up to 74B also as a part.
What benefit?
So in construction, right?
Getting the
The benefit.
When in construction and also when you construct one particular building and the one particular area, let's say A, and you have a one particular building and also at a B, which is excellent to it. You can create a township first, and when a township is created, you can have that flat sold at a very high price because when a township is created, people get entitled to such places.
But this is SRA. They can't sell it to the market.
Lordship, there is not, it has not been yet established as how the binary constructors will utilize this plot, whether they will directly give it to or SRA development.
How can you say so? You just now said there is a notification of SRA.
No, Lordship, the rehabilitation of the people. It is not yet ensured anywhere that the binary will take the complete responsibility of rehabilitation of people on the slum area. Plus, when you develop a slum in Township, I don't have a thing.
Do you deny that this is not SRA project? This is a
SRA project.
Correct. So as per the law, section 4, which she just quoted, the company who gets the project is obligated to provide to slum dwellers. Am I wrong? Market में कैसे बेचेंगे?
Your Lordship, the tender which was awarded to Validity, in pre-bid consultation, other bidders were not consulted, and only Validity was consulted. Is our issue, and that was
That's a different issue. That was established already.
Yes.
My point is, बार-बार कह रहे हैं इनको फायदा हो रहा है, इनको कौन सा फायदा वो तो दिखाइए ना.
Sir, according to slum rehabilitation scheme which I have analyzed, if they got that tender of the slum rehabilitation plot, they get the opportunity and advantage of this slum the slum rehabilitation scheme also mentions that for attracting private developers, scheme introduced transferable development rights. And due to which it also gets the government also provides floor area ratio. So which is whatever the constructor.
I got your point. Your point is they will get advantage of FSI and
yes. Yes, so whatever extra portion they will get.
After development, which they can utilize somewhere else.
Yes, exactly.
Yes, sir. That was also right. But I think
Where go here is the leader can try. You try 6 feet. So, thank you, Mr. Ji. Hello. Thanks, sir. Tell you. See, tell you. No, I'm not giving any instruction. As the time is over, they have not done any well. So they stop?
Yes.
You will not ask anything. Stop.
The level playing field of the line was not reached. The requirement of prior redevelopment experience within 500 meters bears a direct nexus with the project execution, rehabilitation, logistics, and local infrastructure integration. Where they are already building adjacent land, they knew the land better than anyone. The experience asked them for the technical advice to design the project requirements. State Policy 2019 framework allows the government to consult. The experienced private companies to make sure the project is actually doable before they ask for bids. All bidders were subjected to the same criteria, hence equality was preserved. And my lord, Article 29 of the issue justifies the redevelopment decision. I'll come to the conclusion of the issue 1. The slum declaration conferment of redevelopment rights was statutorily authorized based on objective material cited by public welfare and of arbitrariness or malafide. Here, it did not violate Article 14. My lordship is satisfied.
Next.
Issue 2, whether the procedures adopted by the SIC reveal bias or procedural irregularity sufficient to violate the fairness of its finding against Validity. Judicial review over fact-finding report is limited. The SIC is a fact-finding body under Article 226 of the Constitution of India, would examine the decision-making process, not the correctness of the conclusion. The SIC examined 43 witnesses and 87 exhibits over 7 months and issued a recent preliminary report. This agreement with conclusion is not a ground for interference. Procedural fairness was fully complied with. Natural justice requires consideration of relevant material and recording of reasons and absence of bias. In Exhibit D, irregularities were noted, context was analyzed, conclusions were cautiously drawn. After evaluation, it concluded that while procedural lapses existed, they were insufficient to conclusively implicate Validity at this stage. Procedural fairness does not mean every allegation must result in an adverse finding. Thus, fairness was observed. No, no reasonable apprehension of bias exists. The legal test for bias is whether a reasonable, informed person would apprehend a real likelihood of bias. The SIC was chaired by a retired district judge composed of independent experts and issued adverse observation against municipal officers as well. The absence of finding against Frederick cannot itself bias. Not every irregularity maintains adverse inference. Administrative law recognizes that procedural imperfectness is not illegality. My lord, SIC was not bound to infer conspiracy. Sequential events do not equal conspiracy, agreement, and intent. The SIC rightly examined each stage independently and declined to speculate beyond available evidence. Preliminary nature of the SIC report does not dilute its validity. Here, SIC expressly cautioned the further investigation was required. This shows institutional restraint, not informative. With this, I'll conclude the issue 2. The SIC acted independently, followed procedural fairness, applied settled legal standards, and gave reasons finding. There is no bias, perversity, or violation of natural justice warranting inference. If your lordship is satisfied, Mr. Pans will continue with issue 3. Much obliged.
With your lordship's permission, I would like to first begin with issue number 4. The issue is before this court is whether the death of Mr. Rohan Mehta, already investigated and recorded as a suicide, can now be reopened as homicide on the basis of alleged circumstantial material. The respondents respectfully submit that death of Mr. Rohan Mehta was a tragic suicide, correctly concluded by initial police report investigation in the unnatural death case number 46 of 2024. My lordship, page number 1314, Exhibit E. It is clearly stated that toxicology detected lorazepam, which is a sedative. It was within the therapeutic range. The forensic expert categorically records that such sedative is usually taken voluntarily for anxiety or sleep disorder.
Where are you reading from?
Exhibit E, page number 13. The fourth table, toxicology analysis. First point, lorazepam detected approximately 1.5 mg concentrated per 100 ml blood. And in the next page, my lordship, in the interpretation, it is written that it was within the therapeutic range. And the possibility of voluntarily ingestion for anxiety or sleep disorder cannot be excluded. My lordship, there is no evidence of forced administration, overdose, or other incapacitating substances. There was no alcohol, no other drug other than sedative substance. Exhibit F, page number 16. A handwritten note was recovered from the scene, and the forensic science laboratory confirms 85% handwriting similarities. And it also states that minor deviations suggest psychological or emotional distress. There were no signs of tearing or from a notebook or hurried writing were observed. No fingerprints other than the deceased were detected on the note or on the desktop, on the desk surface where the note was found. Other than that, it is clearly established that the note was written by a person exhibiting emotional instability consistent with mental fatigue or stress. There was no evidence of forgery, ink manipulation, or mechanical tracing. The post-mortem examination conducted by Dr. Nirmala Ahuja record the cause of death as asphyxia due to ligature compression of neck, which is medically consistent with suicidal hanging. The post-mortem report expressly rules out homicidal violence. It states that there is no fracture of void or hyoid bone or thyroid cartilage. It is given in exhibit E, page number 14. Madam. Cause of death, opinion, point number 5, cause of death, asphyxia as a result of ligature compression of neck. And on the previous page, page number 13, in both the tables it is written that there was no defensive wounds, no signs of struggle, no fracture of hyoid bones or thyroid cartilage, no anti-mortem struggle marks, no disturbance of clothing, no evidence of restraint or assault. The recovery of body, a lot external examination and internal examination table on page number 13. Point number 4, 5 to be precise. 5 and 6, finger, nails, hand and clothing. And neck structure, internal examination. No fracture of hyoid bone. My lord, the recovery of body from a private log residence with no signs of forced entry excludes third party involvement. My lord, the affidavit of Ms. Ananya D'Souza, though emotionally compelling, is legally insufficient to establish homicide. It is based on subjective perception, private conversations, and it lacks independent corroboration, my lordship. Further, Section 193 of Bharatiya Nagrik Suraksha Sanhita permits reinvestigation only upon emergence of fresh and credible material disclosing a cognizable offence. Every investigation, I am referring to point number 9. Nothing in this section shall be deemed to be preclude further investigation in respect of an offender after a report under subsection 3 has been forwarded to the magistrate, and where upon such investigation the officer in charge of police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in form as the state government may by rules provide, and the provisions of subsection 3 to 8 shall, as far as may be, apply in relation to such report or reports as they apply in relation to a report forwarded under subsection 3. My lord, in the present case, the investigation was complete and lawful. It was based on medical, forensic and scene evidence. No fresh material contradicts the suicide finding. In Kali Ram versus State of Himachal Pradesh, it is held that law distinguishes sharply between what may be true and what must be true. At best, the petitioner's case suggests possibility and not certainty. My lord, to counter the prosecution's question that the body was found on the date of autopsy was 14th June, was because on page number 13, external examination, point 1, it is written that rigor mortis was present in the lower limbs. Rigor mortis is a condition that starts appearing in the body within 8 to 10 hours and settles within 24 hours, which is, in this case, it is present. That is, he died on 12th or 13th and autopsy report is valid. Concluding the issue number 4, medical and forensic evidence conclusively supports suicide. Reinvestigation would amount to the abuse of process. As criminal law mandates strict proof and judicial restraint, the original finding of suicide must stand, and the prayer for reinvestigations deserve to be rejected. With your due permission, can I move to issue number 3, madam? Much obliged. The issue is whether the routing of funds through offshore entities by Validity constructors constitute offense of criminal conspiracy and money laundering, or whether these transactions are legitimate international consultancy transactions. The respondents submit that the entire prosecution is built on suspension without jurisdiction, not on statutory foundations required under either the Prevention of Money Laundering Act or the Bharatiya Nyaya Sanhita. The Prevention of Money Laundering is not a standalone statute. It is triggered only when two jurisdictional facts exist. One is a scheduled offense and second is money derived from that offense. My lord, Section 3 of PMLA can operate only if there exists proceeds of crime, as defined under Section 2, Clause U, arising from a scheduled offense. This is not a matter of discretion, but it is a statutory precondition. In the present case, no scheduled offense is established. The redevelopmental tendering question was never cancelled, annulled, or declared illegal by any competent authority. The award of redevelopmental rights to Vaidehi constructors were based on technical eligibility and lowest bid in accordance with Redevelopmental Promotional Policy 2009. Exhibit E, page number 7. Exhibit B, page number 7. In the internal note on the top, it is written that this communication has been a part of pre-bid consultancy process under the redevelopment promotional policy and does not constitute any commitment, advantage, or preferential treatment towards any developer or bidder. All technical inputs shall be reviewed on merit by the tender evaluation committee prior to the finalization of tender terms. My lord, the Special Investigation Commission constituted by this honorable court, after examining 43 witnesses and reviewing 87 document exhibits, categorically recorded that no direct proof of bribe payments or monetary quid pro quo has emerged. This is stated on page number 7, page number 9. Pardon, my lord, page number 10, finding 4.5. No direct proof of bribe payments or monetary quid pro quo has emerged. When the bribery and corruption are ruled out, no scheduled offense exists. Without a scheduled offense, there can be no proceeds of crime under Section 2, Clause U. In Yash Tanuja versus Union of India, the Supreme Court quashed the PMLA complaint once the scheduled offence did not survive, thereby reaffirming that PMLA proceedings are independent to existence of scheduled offence and alleged proceeds of crime. My lord, prosecution relies on serious fraud investigation officer and Directorate of Enforcement reports, but those reports do not establish criminality. Exhibit I, page number 26. States that further financial forensics are required to establish intent or illicit gain. Further, page number 25, finding 3.3, it also says that the alleged round tripping may alternatively reflect deferred revenue settlements under valid consultancy arrangements. This admission demolishes the prosecution's attempt to draw a definitive criminal inference from the same set of transactions. The ED expressly concedes that the agencies has not obtained foreign bank certified records or mutual legal assistance legal responses, and hence the findings are remains subject to further confirmation. This is reflected on in Exhibit J, page number 28, my lords. My lord, under Section 5 of Foreign Exchange Management Act 1999, read with Rule 3 to 5 of Current Account Transaction Rules, consultancy and professional fees are recognized current account transactions and do not require RBI approval. Prior RBI approval, the remittances were routed through authorized Foreign Exchange Management Act, FEMA.
Section
5.
5.
5. All current account transactions are permitted by default.
Whatever I will say will be
Nothing but the truth.
and nothing but the
Yes, Ananda, this is for the name of the record. Can you just please once again read your name and designation with the occupation that you do?
I am Ananya Legal Director and I am a data analyst.
Do you have any personal enmity or financial dispute with Validity Construction Private Limited?
No.
What Rohan said to you while handing over the hard drive to you?
He stated that if anything happens to me, give this to the authorities. It consists everything they are handling.
Also, did he mention that senior executive have advised him that he to target what he saw and let the things settle quietly?
Yes.
Also, did he mention offshore payments and municipal officials and about all round it?
Leading question.
Sorry?
Chief examinations cannot ask leading questions.
Actually, whatever I'm asking is what she has stated in an affidavit.
So that's not part of it. Why are you asking that?
I want to conclude further with respect to what she is saying.
No, no, but that is part of record. Now, if you have any other further story to be confirmed, just ask as much. Objection is sustained.
Were you fearful? You had said it in your affidavit that how the hard drive was handed over to you. So,
Part of it, you are saying that it is, you have already stated.
next time I'm trying to convey that.
See, you can simply say that whatever is here, there in the statement, do you agree with that? And if she confirms, the chief is over. So why are you repeating all this? Get it confirmation. Show her the statement.
Ms. Anand, I would like to just confirm whether whatever you have
Show it, nah, give it to her.
Do you confirm with whatever statements? I'll just request you to once again go through the statement that you have given. And do you confirm with whatever statement that you have provided to the court?
She has already gone through. Just ask
Do
her.
you confirm with whatever statement that you have provided over here? Whatever statement that you have recorded on paper, do you affirm with all those statements that you have given fully? Lordship, I would like to conclude my Ananya statement. Further questioning and conclusion further what Ananya has said will be done by the former counsel.
I don't have questions for Ananda. I would like to call about this.
No, no, you don't want to cross. Where have you given this statement?
The statement statement of Ananya, it was given before the Honorable Court of Introduction.
In the court.
Yes. Yes, Your Lordship. High Court of Introduction number on 25th day of August 2020.
So that is 164 evidence. Is this a statement given by before the court?
No, to the police.
It is in her affidavit, Your Lordship, that it is given to the court, filed. I, Ananya D'Souza.
The wrong page was of another page, a particular thing which was given by the council. The wrong page was of
Just ask her where did you give that statement?
You have given the statement before Vidya Prachar, both commissioners.
No. You have to ask. You can't lead her.
Have you on
Where have you given?
Where have you given the statement of your affidavit? In front of ED.
But as I mentioned in the
So the witness does not confirm that it is before the court.
You have given it before the ED and not before the High Court. And have you filed the writ petition? With writ petition with respect to filing over the handling over the High Court. Have you filed a writ petition under writ petition number 31/84?
yes.
And you have given that hard drive to the High Court, correct? And later in the seizure was done by police.
Rakesh.
So she has given in front of the High Court. Just now she stated she confirmed it, yes.
No. You asked her, she filed a writ petition, she said yes.
The oath commission was given before. The oath commission means this whole affidavit which is given was given before too.
Before which authority? Ms. D'Souza, this statement which is given to you is given before which authority?
Prakash Thakur.
How do I-
Both commissioners, the High Court was very.
So this is before the court.
Yes, sir.
You are saying ED आपका विटनेस बराबर से तैयार नहीं किया आपने एविडेंस इन चीफ चल रहा है आपकी ड्यूटी है
Yes.
तो आप कोई हॉस्टाइल हो रहे हैं क्या कर दो हॉस्टाइल इनको
Your Lordship, she has said it that she do accounts with whatever statement she has given and it was reported before the High Court.
so whether this statement if she is given before the court whether it was signed or not
Yes, it was signed.
how do I know you have to ask me.
It was signed before.
Yes.
Signed by and
Signed by you means where is the signature make it confirmed
please show your signature.
show nahi confirm
Please confirm that it is you that you signed this affidavit.
Yes.
okay that's it
Yes, with respect to
cross
That is, whether you were a close friend of Rohan Mehta,
Yes.
whether you held any position in Railway Constructors yourself,
No.
whether Rohan mentioned about any threat,
No.
whether
Yes, threat of being followed.
whether Rohan Mehta showed you any written threat issued by Railway Constructors, whether did you personally witness anyone following Rohan Mehta,
No.
how was the behavior of Rohan,
He was anxious and feared and quite distressed.
whether he told you that he was struggling with issues beyond just professional matters,
No.
whether the hard drive was sealed when it was given to you,
No.
whether that during the time the hard drive was with you, can you guarantee no third party accessed it?
According to my knowledge,
Why did you approach Mr. Ritesh Mehta and not directly to the authorities? Why did you approach Ritesh Mehta and not directly to the authorities?
I was concerned. I was told by my counsel,
Who's Ritesh
legal
Mehta?
counsel.
Cousin of Rohan. Whether you believe that Rohan Mehta was in danger is based on what he told you and not any direct act by Vaidari.
Yes.
My lord, this established that there was no direct threat to Rohan Mehta from Vaidari constructors. There was no complaint filed by him.
You, alright, that I got it. Any other witness? You excuse. Next, any other witness?
Witness number 2, Amitabh Rao, please proceed to the witness box.
Please look at the judge and take your oath.
I'll say the truth and nothing.
Please tell to the judge your name and designation.
My name is Amitabh Rao. I was an internal auditor by the instructor.
Please look at the judge and state. Look at the judge and please speak.
I was an internal auditor with by the instructor private.
And this statement of this one affidavit is given by you. Please confirm to the court. You want the affidavit. Before whom this affidavit was given?
Before the meeting and the magistrate. It was disclosed to the ED and then finally it was in front of magistrates.
The confirmation that this sworn affidavit belongs to Amitabh Rao is done with.
You have only taken out the contents. Whether it is signed by him. Not
Is this sworn affidavit signed by you, Mr. Amitabh?
Yes.
And so it is signed by him. He has given this oath commission before the magistrate in Vidya Prachar Samiti, and thus this statement are given to Amitabh Rao stands still.
Just for the record, please state your full name, official designation.
He is already done.
At the time of your resignation, were there any disputes between you and Vaidari constructor?
No.
Are you sure about that?
No.
And in the affidavit, it is written that there were disputes. Page number 42. Point number 2. Background of it. Point number 2. Background of witness.
So it was my personal reasons I mentioned. Which dispute are you're talking about my resignation.
Alright, did you personally witness any payments being made by the Vaidari constructors to municipal officers? Does your testimony rely on direct evidence of bribery? Isn't it possible that these payments were legitimate consultancy fees routed through international partners?
In my view, it's not possible because it was the point of my findings during the internal audit.
Alright. As an internal auditor, did you have final authority to classify, approve, or authorize the nature of financial transactions?
I was not the final authority.
Were you part of board of directors or senior management who were responsible for decision-making process?
No.
Okay, that's it.
Your excuse. Next.
I would like to call upon the investigating officer.
Witness number 4, SFIO, please proceed to the witness box.
Whatever I will say, that is truth and nothing but the truth.
Officer, please tell the court that you are the liaison and investigating officer for the serious fraud investigation office report and the enforcement director.
Yes, I am the officer of Serious Fraud Investigation Office and the Enforcement Director. It's a joint investigation.
Uh, just one question to you, that on whose recommendation, officer, you started your further investigation?
It was the recommendation of the SIC formed by the
Lordship, I am making the point that on SIC's recommendation, the SFIO and AD had carried out further investigation. Third, the respondents state that the SIC's reports are valid and they are only relying on the conclusion it states, but they are not ignoring the recommendations made for further investigation. In the prayer, they have stated.
He's not SIC. Ask his questions.
No, I am stating
He
from
is
this
appointed
state.
by the recommendation of SIC.
Yes, sir.
What did he do? Ask him.
You are Validity constructors transferred 18.6 crore to offshore entities, correct?
Correct.
These entities lack
सो रहे हैं आप लोग? यार लीडिंग क्वेश्चन पूछे जा रहे हैं आप बैठे हुए.
already he has confirmed that the reports made by him, the reports made by both of them are valid. Your Lordship already confirmed that both the reports are
Where did he
valid.
confirm? You just simply said.
I asked your Lordship and
No,
yes,
you
he said
cannot
yes.
ask. That's what I'm saying. Judge is judge साहब जग रहे हैं, सब सो रहे हैं आप लोग.
Please tell to the court regarding your inputs with respect to reports.
With respect to the report is the investigation has been carried out by me. Okay. But the reports were made by my seniors. So the SFI report is made by the director, division second in investigation, and the ED reports were made by the deputy director, Aditya R. Kapoor, and in the supervision of Vidya Goswami, which is joint director at ED.
Please tell to the court the findings of it.
The findings of the SFI report is basically the violation of section 179 subsection 3 clause D of Companies Act, section 447 and 448 of the Companies Act, and in the ED report it's section 3 along with section 44 and 45 of PMLA Act.
Your Lordship, just confirming that the officer has confirmed section 447, which is the scheduled offense under money laundering. Further, what are your findings of ED? Please tell me.
So the findings of the ED report states, my findings states that the transactions have happened in a round-tripping manner. So basically, the funds have initially got transferred, remitted to the offshore entities, which is Cresthill Global and Northwell Holdings, which is 18.6 crores from the Axis Bank account to Cresthill Global. The Cresthill Global has further transferred into Northwell Holdings. Northwell Holdings is nothing but a subsidiary of Cresthill Global only, which is registered at the same place. And why I specifically and explicitly said that these entities are shell entities, because the entities does not have any employment records over there. The entities are registered at the same place. So these are the crucial things which I observed in my during my investigation. Further, these funds have returned back to India in the Vedai Constructions bank account, stating as a revenue. So this making that the same structure what needs to be observed into PMLA. That is one of my findings.
Whether your findings before this court are part of a preliminary investigation.
Yes.
Whether your report contained any final determination of criminal guilt against the constructors.
It requires further investigation.
Whether you have conclusively established that this transaction violated FEMA or RBI regulations.
FEMA and it focus more on DMLA.
Whether the offshore transaction you examined were routed through formal banking channels.
Yes, it was.
Whether you have whether you have personally verified the absence of consultancy services corresponding to those payments.
I have relied on the statutory auditor's report. Measures are the Rejine company. In the notes to accounts in the financial year 22-23, Architect Rejine company has mentioned the fact that in the notes to account there was no service agreement being available, no invoices being available. So, and statutory auditor's report is a legal document and has to be considered during the investigation.
My lord, I want to repeat the question again. Whether you have personally verified the absence of consultancy service corresponding to those payments.
No service agreement being available.
Point to be noted. Whether the digital data relied upon you was extracted personally by you.
Can you elaborate more on the question specifically?
The data you relied upon was personally extracted by you.
Personally extracted by me. I have taken the certain.
And later there was no narcotics found. And the nature and the cause of death is asphyxia.
What is the, please tell them what the nature of the
Nature of death is still pending, but cause of death is asphyxia.
does this require further analysis?
Yes, it does require further analysis.
Please tell to the court whether your report is conclusive or not.
It is still inconclusive due to the leakage not being horizontally placed.
And what are your findings with respect to, what are your remarks with respect to leakage marks?
Leakage mark was pale brown in color and it was incomplete, yet it was consistent.
It was consistent or
Due to the strangulation, it is incomplete. But
these are the remarks, leakage mark. Okay. What were the
it
remarks?
was incomplete and horizontally placed.
And where it was typical with self-sufficient practice or
It is not. It is able.
Your Lordship, this is to be noted that the court was inconclusive in nature, and the leakage mark is not typical with suicide and hanging, and further investigation is required.
Could you inform the court about your education qualification?
I'm an MD in forensic medicine.
For how many years have you been practicing medicine?
Over a decade.
Were you the medical officer who conducted preparation?
Yes.
What does absence of any fractures to the hyoid bone or thyroid cartilage indicate in forensic practices?
It depends on, there are many cases where it can be due to less strangulation, but here the ligation are being horizontal, it can be said it's still inconclusive to suicide or homicide.
Alright. During your examination, did you observe any defensive injuries such as abrasion, scratches, or signs of resistance?
No, I did not.
Point to be noted, my lord. Apart from the ligature mark, were there any external injuries
No external injuries.
that were suggestive of homicidal violence? Did the toxicology analyze any sedative substance?
Yes, lorazepam.
What was the range?
It was 1.5 milligram concentration per 100 ml.
Was it within the therapeutic?
Yes, it was.
Were there any other drugs found in the body of the deceased?
No drugs found.
You have recorded the cause of death as asphyxia due to ligature compression and not as asphyxia due to homicidal violence. Am I
Yes,
correct?
findings.
That's
So, Rashid, you may comment and start with the closing statement. Question number 1 to answer this question to conclude. Your Lordship, at the close of this proceedings, the petitioner respectfully submit that this case is not confined to a redevelopment project. It concerns how public power was exercised, how public resources were diverted, and how truth became dangerous, and it surfaced how money vanished offshore, and how truth died in silence. When power chooses favorites, equality becomes casual. With respect to issue number 1, Your Lordship, the redevelopment rights in favor of Vijay constructors were not an outcome of fair process. They were the result of prescriptive decisions. Later, floating layout existed before the slum notification, emails coordination, and tender follow decision. The tender that begins after the winner is chosen is not a governance, it's a theatre. With respect to issue number 2, Your Lordship, my fellow respondents are only agreeing that a SIC committee which was formed and all the procedures are correct. But they are not agreeing with the fact that the results are incorrect. An investigation does not become biased because it's uncomfortable. You are already saying that the SIC committee which has been formed is correct, and the investigation also done by it is also in the correct way, which has been further forwarded to SIC team. With this, I like to close my further closing statement, which will be continued further by the co-counsel. Much observation.
Your Lordship, with respect to issue number 3, with respect to issue number 3, the agreement between two, the agreement, I'm sorry, I beg your pardon, Your Lordship. Yes, sir. With respect to issue number 3, the routing of offshore round tripping of funds, the money laundering process, and using the FFT topology thus constitutes the offense under Section 3 of the Money Laundering Act, and criminal conspiracy under Section 61 of the Bharatiya Nyaya Sanhita. Your Lordship, in addition to that, backdated invoices and purposeful decision of non-disclosure of consultancy revenue in the financial statement notes to account also attract Section 336 forgery, Your Lordship. Further, no deliverables were produced, consultancy agreements were backdated, invoices were backdated, no board approval existed, and statutory auditors confirmed non-disclosure of such in their financial statements. This was done purposely by the Vaidehi constructors, as they very well knew, as already confirmed in the SFIR report, if these transactions were legitimate within the prescribed limit, then there was no reason to hide the same by the Vaidehi constructors. Here the intention to hide creates the guilty mind, and thus the collaboration of pre-tender layouts between the MCBN officials and MCBN and the Vaidehi constructors creates meetings of minds and connecting it with the round tripping, thus creates criminal conspiracy under Section 61. Further, Your Lordship, the death of Rohan Mehta, is not yet conclusive, and further reinvestigation is required. The postmortem report is of inconclusive nature, and thus we pray before this honorable court with our set prayers, and further reinvestigation should be conducted of Rohan Mehta, and further the ED report should be taken into consideration. ED and SFI report should be taken into consideration. Much obligation. The Lord's cross-examination of Dr. Nirmala Ahuja clearly establishes that post-mortem report findings are medically consistent with suicidal hanging. It does not support homicidal violence. There were no fractures of neck structures, no defensive injuries, no signs of struggles, and no external injuries suggestive of assault. The sedative detected was within the therapeutic range, and it is consistent with anxiety and sleep disorder. Most importantly, the medical expert herself recorded the cause of death as asphyxia due to ligature mark and not as asphyxia due to homicidal violence. In absence of medical indicators of violence, the prosecution's theory of murder is speculative and unsupported by foreign evidence. So now the One of the case fails at every jurisdictional threshold as established in my arguments. In the absence of a scheduled offence, the PMLA cannot be invoked. Without proceeds of crime, Section 3 has no application. What the record discloses at the most are regulatory or corporate lapses, which cannot be elevated into offences of money laundering. Equally, there is no material establishing mens rea or meeting of mind so as to attract criminal conspiracy under Section 61, Clause 2 of Bharatiya Nyaya Sanhita. As penal courts strictly demand construction and suspicion cannot substitute proof, the respondents respectfully submit that the offshore remittances were lawful, FEMA compliant consultancy transactions, and the proceedings under PMLA and BNS deserves to be quashed. Such proceedings would amount to an abuse of process. Much obliged.
Regarding to issue to my lord, the petitioner themselves are confident under issue 2 that the SIC conducted a fair and unbiased inquiry. Having accepted the validity of the commission's finding, they cannot attempt to undermine the same report under issue 3. This contradiction is not rooted in law but the selective dissatisfaction with the outcomes.
Now, in this moot court, I must compliment all the participants, including both the researchers as well as the audience who will be very attentive. The court staff will be very well trained. And before I say something, let me make a confession. It's very interesting to listen to my confession. The confession is that all of you surpassed my imagination. You were so good that I couldn't even imagine that at your age I could even perform half of what you did. Well done. difficult to judge you all. You are already prepared lawyers. Wonderful. I mean, hats off to your faculties who are training you. Hats off to your whatever background you come from, your parents, your guides, your hard work. My God, this is exemplary. I had never come across such wonderful performance. And the truth is, if I could, I would bring the actual lawyers over here to learn from you all how to perform, how to be so accurate on the point and so precise preparation. See, 2-3 fundamental points which I observed. All of you have understood the proposition so thoroughly, so well, because you were able to relate it to the clause. What is written in which clause, where is it? That shows your level of preparation. And this is what happens in actual court, that when you submit a brief, you must know what your brief contains. The second aspect is legal aspect. When you master the facts of your case, you have to supplement it with the provisions of law. There also, you fall too good. See, what I was judging was how to choose the best out of best. And have you ever understood that how difficult it is? When everything is best, how to find out who's better than the best? You all were so good. Again, a confession. Thank you, the organizers, who have given me a pencil and a rubber. Why I say so? Because I kept marking you and I kept rubbing it. Because whenever I marked you for something, you excelled. And I had to revisit to again rub it off and to increase the marks. So, wonderful. I really leave from here with a very cherished memories, and I wish you all good luck. Welcome to the bar soon, and enrich the bar with your presence. You all are very good. And one more thing, as like in every competition, howsoever difficult it is for the judge, somebody has to win and somebody has to lose. That's the nature of every competition. Thankfully, I'm not an actual judge to judge your matter. I was just judging the lawyers. Because your matter itself, you argued so well that had I been the actual judge to judge whether there was a financial fraud or there was none, whether he was clean or not, it would have been very difficult. Because you were defending whether he so well and you were giving the charges so well that they did everything wrong and they said we did nothing wrong. My God. Whoever drafted this proposition, do I know?
Yeah.
Full marks to Wow. You should be into films. Right? To write such lovely scripts. I mean, दोनों को fairness के साथ balance करना. मतलब you have given points to the prosecution as well as to the defense, petitioner, respondent, so balanced script. It's really remarkable how you drafted it. Very good. Fantastic. I mean, I'm amazed with this quality. Thankfully, your institutions must be proud of you, and I'm really telling you, when we studied law, 2-3 things I must tell you all how fortunate you all are. When we studied law, our classrooms were not air conditioned like this. We didn't have this wonderfully decorated courtroom for having moot courts. We did our moot courts in simple rooms, putting tables, chairs, and behaving as if we are lawyers and there is somebody who's a judge. We didn't have such wonderful structure. What you all did is like you're a very fortunate generation that you got all this. And councils, do you know that you all are very fortunate to have such wonderful researchers? We didn't have. Our job was to research ourselves. We didn't have such researchers or background or something. We did it ourselves. We faced the questions of the judge. और आपको पता है जब हम लॉ पढ़ रहे थे अभी मुझे नहीं मालूम क्या चल रहा होगा कीज चलती थी तो उस जमाने में झपवाला करके एक सीरीज थी जो चलती थी अभी क्या चल रहा है मुझे नहीं पता अभी भी झपवाला चल रहा है ना तो मैं आपको एक एक्चुअल सिनेरियो बताऊं बिफोर आई क्लोज इट एंड लेट्स डिस्कस बिकॉज़ इट्स टू लेट व्हेन आई बिकेम अ लॉयर soon after being enrolled, I was given a brief to argue the matter before the court of law. And it was really a very thrilling experience to get an actual brief to argue before the court of law. So, what happened is, my 4 batchmates had joined my office, my father's office. So, we were 5 of us from the same batch, like all 5 of you or 6 of you joined the same office. So, you all are bum chumps. And so you know each other so well and you joined it. So it was all fun. When we got the brief, it was decided among all who would be the counsel and who would be assisting. Unfortunately, I was chosen to be the counsel to argue the matter and 4 of my colleagues were to assist me. And you know, there is always a rank. First assistant, second assistant, third assistant, fourth. These are the ranking which is actually happened in every court. So there were toss among 4 of them who will be the first, second, third, fourth assistant, and I will be arguing counsel. So when I started arguing, the point somewhere stuck is Article 21 of the Constitution of India. You all know that? Yes. What is that? Wow. So intelligent. Yeah? Good, very good. We didn't know till then. You know that. And I was arguing Article 21 before the division bench of the High Court. 2 judges sitting in a very somber face. And when I started arguing, I was talking about Article 21, like you all were quoting this law, that law section, and I had to ask which act. Similarly, I was talking Article 21. And the judges, somehow they other felt that I am going haywire. They felt that I was not sticking to Article 21, I was reading something else. So, I said, Mr. Chaturvedi, can you read Article 21 for us? Like I said, please read this section of PMLA. Sure, sir. And like we used to observe my father and other senior counsels, how do they behave in the court of law. So similarly, I said, yeah, of course, father. I turned to my first assistant, please provide me Constitution of India. And he was a little disturbed. He's the second, please provide Constitution of India. He said to the third, please provide Constitution of India. And he told to the last one. And he last one by then searched and said Constitution of India. So it came to me, Constitution of India. I opened and I started reading. When I started reading, the judges frowned. I'm reading Article 21 of the Constitution. Are you sure? I said, yes, Lord. The other side lawyer, who was equivalent to my father, was a senior lawyer, and knew me from childhood, he just stood up and peeped. He said, look, please ask my learned friend, which jurist is he referring to for reading Article 21? And that was when the judges said, which book are you referring to? And I said, yes, no. And when I turned the page like this, it was Java. Now this idiot, my class, we were just passed out. This idiot brought Jhabala along with him. And when I'm asking constitution, he gave Jhabala. See, what was the embarrassment which I faced before the bench? Because that bench gave a very satirical. Listen. So sorry. The bench, in a very satirical tone, said. The bench, in a very satirical tone, said, "Oh, you're referring to such a big jurist. That is beyond us. Please spare us with the bare act of Constitution." So that was the embarrassing moment. Why I gave you this anecdote of my personal life. Let's see where I was. Even after enrollment as a lawyer, full-fledged lawyer, appearing in the actual court with those bunch of jokers who were assisting me, and think where you are. You are so well trained, and you are not supported by jokers like me, but actual researchers who are giving you actual research papers and scenes. It was so good. It was wonderful experience, and I wish you all good luck. And I wish to get more such opportunities to encounter such lovely younger generation lawyers. Fantastic. Thank you so much. Jai Hind. All right. You want this paper? Shall I leave it here? And if somebody wins or loses, please don't lose heart. It's just that it was very difficult for me. Somebody has to win, somebody has to lose. But you all are good. And you are too good. Please don't even take it as a benchmark that this fellow is more competent and that fellow is more competent. Everybody of you are excellent. Right? रिसर्चर जी थोड़ा भी मन में मत लगाइएगा, अगर कुछ हो तो मुझे मत गुस्सा निकालिएगा, क्या समझाएं, मैं बहुत डिफिकल्टी में था. ऑलराइट, थैंक यू.
Participants are requested to move to L3, the state element.